Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's topic is, what are the generic and biosimilar industries worried about? Current competition law issues impacting the sector. Pharmaceutical competition is absolutely critical globally. In the United States, it's been a focus of the new administration, but really around the world, competition in healthcare is being seen as a way to deliver more healthcare. One of the keys to that is getting inexpensive drugs and other medical products out to people. Today, we're going to talk with an expert who's going to explain what are some of the competition issues that are impacting getting inexpensive pharmaceuticals and other medicines to folks who need them. My co-host today is Matthew Hall. Hi, Matthew.
Hi, John. It's good to be back.
Great to see you. Matthew, what are we doing today?
As you said, John, we're going to be discussing the key current competitional issues impacting the generic and biosimilar industries, focusing on the EU.
And why is that important?
Well, medicine pricing and competition remains an important and very emotive topic in the EU. And as you also mentioned, generic and biosimilars are important in keeping prices down and providing competition in the market. And in addition, the pandemic has given rise to particular issues for the industry, which they have had to deal with.
Who's our guest today?
We're very pleased to have Adrian van den Hoven, who is Director General of Medicines for Europe. Medicines for Europe represents the European generic, biosimilar, and value-added medicines industries as their official trade association. It began over 20 years ago as the European Generics Medicines Association, or EGA, later including biosimilars, and more recently expanding into value-added medicines. Companies represented within Medicines for Europe work across, I understand, over 350 manufacturing sites in the EU and Europe. Hello, Adrian.
Hello, nice to be here with you.
Thank you very much for joining us. Well, as John and I have mentioned in the introduction, we're going to be talking about generics, and I looked it up, and it seems that these account for something like 67% of all medicines used in Europe. Pretty impressive. Biosimilars, new to some, but the first biosimilar was approved by the EU, I understand, in 2006. These are medicines which are very similar to existing medicines without any difference in their efficacy otherwise. And there are a lot of issues going on in these areas, as we mentioned. Let's just dive right into this. We've seen a lot of litigation and regulatory investigations in terms of the originators and others trying to put up barriers to generics and biosimilars entering the market. I know that you've published white papers on this, or the Medicines for Europe has, and a particular issue which is actually pretty hot now due to a European investigation launched in March 2021. And also I should mention we had Isabel de Silva from the French Competition Authority come on our episode 96 to talk about this, is denigration by companies of generic products. So what is the Medicines for Europe viewpoint on denigration of generics and biosimilars?
Well, I think that's actually a really good question. So Just to put it a little bit into context, so you're spot on with your information. So generic medicines today are close to 70% of the prescription medicines dispensed in Europe. I think it's around 80% in the US. And they are really the majority of the medicines that patients would consume in Europe. A lot of patients in Europe, they don't know that these are generic medicines because in practice, our medicines are branded in Europe, whether it's a generic or a branded medicine, they all have a brand. So patients don't know actually they're taking generics in Europe. So there's really not so much of an issue there. Now, where there can be an issue is you mentioned biosimilar medicines, and we're celebrating this week the 15th anniversary of the launch of the first biosimilar medicine in Europe. And that was a world first because we have about 10 years advance on the rest of the world in these products. Our industry invented biosimilar medicines. So we have a lot of experience. I think we have 2 billion patient days of use of biosimilar medicines. And these are heavily monitored products from a pharmacovigilance perspective because they're biologics. And all of the pharmacovigilance information shows a positive result, meaning no difference between the reference product and the biosimilar on the market. So that's very positive. That said, biosimilars being a complex product, what you do see is that it's relatively easy to denigrate this product because of the complexity around discussions of biotechnology, how biological products are approved versus how chemical products are approved. It's a more complicated process, and so it's an easy opportunity for originators or others to claim that these are not therapeutic equivalents, and consequently to try and block head-to-head competition between biosimilars and their reference product. So I think the investigations into denigration are very relevant for biosimilars because there is a big risk of denigration to limit the head-to-head competition between the biosimilar product and the reference product in Europe. And we know it's something that is watched very, very carefully by competition authorities to see if that kind of thing happens. And denigration can be in two forms. It can be, basically misstating the regulatory approval of the product, so saying that it's not safe or it doesn't meet the requirements of EU regulatory approval. But another way of doing it is to misinform authorities, so to misinform procurers or other authorities about the medicine to justify a kind of segmentation of the market. And because biosimilars are not substitutable products, like most generics are substitutable by a pharmacist, in the case of biosimilars, they must be actually prescribed by the physician. This, let's say, opens an avenue for such an abuse. And I think that's carefully watched in Europe by the authorities.
That's interesting, Adrian. It's very interesting to you pointed out that it's been such a long time since biosimilars have been in the market. It shows the EU, in fact, leading the way there. There's a lot of criticism often that the EU is anti, science and advancement, but there seems to be a great example of it being ahead of the rest of the world, including the US. You made a reference there to abuse. So we're looking at denigration or subtle denigration, I think it's sometimes called. What is the actual competition law infringement here? Are we relying on anti-competitive agreements, or is it only abuse of dominance? What is the basic issue here when it's challenged or looked at?
Yeah, so I think for denigration, it's abuse of dominant position, and it's due to the fact that the reference product is usually the sole product in the market, and of course has access to all of the key decision makers in the market, and therefore denigration or misrepresentation of the facts even to those key stakeholders in Europe. It's mostly governments, right, directly or indirectly, then can be considered an abuse of dominant position. And I think the French competition authority kind of set the bar for this in Europe. But it is widely distributed, and for sure this is an issue that everybody keeps a close eye on.
Yeah, thank you again for plugging our number 96, our Curious Amalgam, where, as I mentioned, we had Isabel da Silva on talking about these French cases, where, as you say, the French authorities have been leading the way for quite some time, including a very large investigation and fine recently in a collective dominance case. So the listeners could go back and listen to that one. I know that there are lots of other areas that Medicines for Europe focuses on in terms of restricting or limiting entry of generics and biosimilars, and a particular issue that is a bit obscure maybe to the lay person is the issue of divisional patents and using those, again, not competing on the merits, but using those to delay and restrict entry. I know Medicines for Europe has done a lot on that too. What is your concern there?
Yeah, well, surprisingly, this is not a new issue. Matthew, you will be aware, but maybe John, this might be new to you. But in 2009, the Commission did something called a sector inquiry, where they looked into the pharmaceutical sector to see if there were competition law issues across the sector itself in a kind of structural way. And at that time, there were there were a lot of things that came out of that sector inquiry, but two important ones. One was patent linkage, and the other one was divisionals. And at the time, the competition authority kind of ordered the European Patent Office to change its policy on divisional patent applications. So divisional patent applications are that you have a main patent or a main patent family, and then you can have divisionals of that same patent family. So a number of other patents associated with that main patent, if you wish. And where this becomes a tricky issue is you can remove the main patent, but continue to have the application for the divisionals to that same patent continue to live, if you wish, in the patent system, which means you can defend those before a court. You can say, I have a patent based on a main patent that has been withdrawn. And of course, this doesn't make a lot of sense. But that's in a way how the policy was working. And when the European Patent Office was ordered by the Competition Authority to change this policy, it restricted the ability to introduce divisional patents along these lines in pharmaceuticals. But surprisingly, 6 years later, the EPO reverted back to its old policy that the Competition Authority had asked them not to do. And this reopened the possibility to use the patent system in that way. And this has led to an increase in patent litigation around divisional patents related to patents that have been withdrawn. So it doesn't make any sense from a patent perspective. But because the national courts don't understand the proceedings, this leads to this. And this can then delay the entry of the generic or the biosimilar by several months. And so there is an ongoing investigation into one such case right now in Europe. But I think the real issue here is to do with the policy. So, the Competition Law Authority had asked the EPO to change this policy. It did. Then it reverted back to the old policy, and the problem reappeared almost immediately. So I think the real issue here is to correct the policy of the Patent Office. That should be something relatively straightforward and easy to do. The difficult thing in Europe is that the European Patent Office is a kind of parallel legal system to the European Union's own legal system, and it is intertwined with the European legal system, but it's not specifically a part of it. So the European Parliament, the European Commission, the Council, which is where the member states sit, they don't have direct authority over the patent office. And so this is, kind of an odd discussion that needs to take place between parallel legal regimes. So I think that's one of the big challenges there. But right now there's a competition law investigation, but I think the real issue is a policy change at the patent office.
As you say, there's an investigation. That's the Teva investigation, which started in March 2021, I think you're referring to there, Adrian. And it's interesting to hear about the EPO. So you're saying that it's difficult to put pressure on the EPO as you could do in a more normal situation. Is that the issue there?
Yeah, so I think, like I said, the EPO is its own legal treaty and system which operates in parallel with the European Union, which is a legal treaty system, but they're intertwined because European legislation refers to the Patent Office and confers certain responsibilities on the European Patent Office on behalf of the European Union. But it doesn't have direct legal authority like the European Medicines Agency, for example. The boss is the European Commission. So if the European Medicines Agency does something the European Union doesn't like, the Commission calls and says, I'm your boss, change that. With the EPO, it's not that direct line of authority between the executive, which in this case is the European Commission, and the EPO. So it's a more subtle conversation, but we still think that conversation has to take place because of the fact that the EPO's policies have such a huge impact on competition in the market, in this case, generic and biosimilar launches.
Yeah, and really providing the framework for an alleged abuse in that Teva case by Teva in relation to using the system, as I understand it. You mentioned the sector inquiry. And also you mentioned another key issue from that, Adrian, patent linkage, which again, I understand to be quite related to the regulatory system, but could you take us through what the issue in relation to patent linkage is?
Yeah, so I think for the American listeners, you have a patent linkage system for pharmaceuticals, which comes from the HACS. I can't remember. I better stop. Hatch-Waxman legislation, which basically is a kind of incentive for generic or biosimilar companies, or specifically generic companies, to challenge the originator's patents in a specific process, and then they get a reward on the market for doing so. In Europe, we don't have such a reward system for generic medicines. So when you clear the way of patents, which is something you do to launch generic or biosimilars, you litigate the patents of the originators because they will have, literally hundreds of patents on each product. So we do a clearing of the way process, but you get no reward if you are the company that has cleared the way. And so as a consequence, we also don't have a patent litigation system linked to the regulatory process, which means that you cannot delay the regulatory approval or launch of generic medicines because you have a or multiple patents on it. The originator has to defend its patents in the court system in Europe. So in theory, therefore, we should not have a patent linkage system in Europe. In practice, however, what we see is that we have forms of patent linkage popping up in different countries. So in Portugal and Italy, we have a formal patent linkage system linked to what is called pricing and reimbursement listing. So in Europe, most countries have a regulated pricing, so the government sets the price. And if you want to be able to go on the market, you first have to get this regulated government price, if you wish, and then you can then you can go sell to a wholesaler or what have you. Without this, you cannot actually enter the market in most European countries. And so in Portugal and in Italy, you have a form of patent linkage when you apply for this government mandated price listing process. And this typically delays generic launches. So as an example, when we launched generic versions of some HIV drugs, they arrived later in Portugal than in the rest of Europe because we were going through this obscure patent linkage process. But it's getting worse than that because we're seeing now in other countries similar forms of patent linkage processes. A lot of it linked to this official listing requirement that we have because we have these regulated pricing rules. So we have to perform this administrative act. We are often caught in a patent linkage process, which is not defined in the law. So there's nothing in the law that says originators can do this, but they use threats against the body that does this administrative act to get that body not to issue those official price listings. And this, of course, then delays our entry into the market. And like I said, the main experience we've had has been around the launch of generic versions of HIV drugs. And this has had an impact, of course, on our companies, and it's extended the duration of litigation and various things like that around there. But it's also what it has meant is that it's delayed price competition with very direct effects on patients, because for many of these HIV drugs, some of them may have a prophylactic use, which basically means a preventive use. You can use them to prevent contracting HIV. But European governments would not pay for that, or patients could not afford that until the generic actually entered the market. So this extended delay, if you wish, also extended the delay to which you could afford this prophylactic use. So I think here again we have an issue, and again this is not a new issue, because in 2009 this same competition and sector inquiry stated that the Commission should formally ban this in primary EU legislation, so declaring this as an illegal activity, an anti-competitive activity. And they actually proposed a law shortly thereafter to do that as part of a much bigger law on reform of pricing and reimbursement, which is actually EU competence. It's not member state competence. But unfortunately, that law was not passed. There was a dispute over a different part of the law. And so the whole thing fell apart. So now we are faced with these patent linkage issues that are delaying our entry into the market.
And the competition law angle here, you made a reference to it, I think. But are we looking here again at abusive dominance and a kind of type of abusive litigation where the originator is making comments and trying to put pressure on the regulators to use these rules? Is that where the competition law would cut across this?
Yeah, so the sector inquiry declared this practice anti-competitive and unlawful, so used the double term it was the Commission's sector inquiry. And indeed, I think what it is the thing that's complicated here is these bodies are authorities, but with more of an administrative function than a regulatory function. So we have the medicines agencies that approve the quality, safety, and efficacy of the drug. And then we have these administrative bodies that put your product on a list and you get a kind of government mandated price. Like generics have a kind of standard price in Europe, which is a discount to the originator, if you wish. And only when you are on this, go through this administrative act and get on this list, only then can you actually start to commercialize your product. And so it's a kind of administrative regulatory process that is trapped or that is delayed.
Yeah. Okay. Let's. That's extremely interesting, Adrian. Let's move on to another topic, the COVID emergency. Obviously, as we know, it kicked off in Europe really in February, March, April of 2020. And then the first comfort letter for a very, very long time came out of the European Commission. Comfort letter being an indication that the Commission is happy with an arrangement and would not propose to take action against it broadly. So this was a very famous comfort letter, and I think a big victory for the people at Medicines for Europe. So you and your team, could you give us some background to what happened there? And also, it'd be interesting to hear, really, is it still, are the arrangements there still operational? Do you think it's worked? Have there been any kind of issues around it? It'd be fascinating to hear about that.
Yeah, so I have to take you back a little bit in time. So to sort of January 2020, our industry was one of the few industries in Europe that thought COVID-19 would be a very, very bad thing in January 2020. Most of Europe, including all of our authorities and governments, did not think that COVID-19 would affect Europe. They thought it would be mainly an Asian issue, like SARS-1 was mainly confined to Asian countries. So the official position of almost all governments and the EU and Europe was that this was not going to affect Europe. We were really outcasts in saying, Europe's got a major problem coming and we need to get organized now, meaning industry and the European Commission, to get ready for something quite terrible. We were probably more advanced because we were operating in China and could see the impact in China, and also we could see the impact on our production in China, which is that China shut down our factories, so our factories owned by us, but also factories supplying us. And so, there were no more supplies from China. We were able to manage that with our own production here in Europe and with reserves that we had, inventory, if you wish. But we knew this was a very, very ominous sign of bad things to come. And then when the virus actually started killing Europeans, we said, look, this is going to spread all across Europe. And, we're going to have a lot of very bad patient situations across Europe. But again, we were kind of alone. This was in February. No one was really thinking that Europe would be hit like this. And then in March, Italy really got struck first. And what we could see in Italy was that no matter how much hospital emergency medicine, like anesthetics, injectable medicines to treat COVID patients, no matter how much we sent to Italy, they kept consuming it all, like over and over again. We kept sending as much as we could to Italy, and they just kept consuming it all. And we were wondering what they were doing with it. And then we started looking at how COVID patients were treated, and they were basically put on respiratory machines for several weeks, very, very long time, and they were put into artificial comas. So each individual patient was just consuming so much of this medicine, it was off the charts. So we calculated then what would happen if all of Europe consumed this much medicine, let's say equivalent to Italy's consumption at the time. And we realized that, we would likely have a very large scale shortage of these medicines, which would have meant that patients could not be put on mechanical ventilation, which of course would mean they would die. And so at this point, we told the Commission we have to figure out a solution because the demand is going to go so high. We were estimating about 2,000%. It was actually around 1,000% of annual consumption within the next 3 months. And so you just don't have this kind of stock lying around. So you have to produce it. And this is where we realized we would have a problem because we have to produce this amount very, very fast. And what became very difficult is we brought together the main producers of these medicines, but you can't have this kind of conversation under normal circumstances under competition law. So we couldn't talk about anything. So we went to the authorities, both the competition authority and the health authority, and said, look, we've got a big, big problem. We are sure to have a shortage. We've got to find a way to be more efficient. But to do that, we have to allow competitors to cooperate under certain clear rules. And that's where the Commission actually adopted two things. First, they adopted a decision, which was something like what they call in the U.S. the voluntary cooperation under the U.S. Defense Production Act. So they actually adopted a decision, which is like a soft legislation. And then they adopted the comfort letter as part of that decision for medicines for Europe. And all that really did was set out very clear rules for us under both competition law and health policy for what we were allowed and not allowed to do. So we had to find every company who produced any of these medicines in Europe, no matter how small they were, and invite them to join the project. And then we had to, when we worked together, we were under the direct surveillance of the competition authorities. So they were monitoring us directly, and we had to send us every information about the project we had to send to them. And finally, we had to create a special forum between the competition authority and Medicines for Europe, that if we would do anything beyond, let's say, just talking about regulatory issues, and so we did anything talking about production or talking about allocation to different European countries, we could only discuss this in a special forum that was sort of jointly established between Medicines for Europe and the competition authority. It turned out that we didn't need to use that, so we didn't actually use that forum, although we created it. We didn't use it because in the end we found alternative solutions to this, which were mainly that we were granted regulatory flexibility under pharmaceutical regulation to be able to produce much faster and to re-import drugs that we had exported to China that China didn't need anymore. And so this was basically how we solved the issue. And so we didn't have to have any real industrial cooperation from a competition law perspective, if you wish.
That's interesting, Adrian, how it played out. And it's fascinating to hear the background to that. I think we don't want to keep our listeners for too long, but I know you have a very brief comment, if you could, about looking forward, you think there's a need for primary law here to deal with this type of situation again. I think you have a real concern about that. Could you just give us 2 sentences on that, please?
Yeah, so as I mentioned, there was this kind of decision to enable this cooperation. I think we need a tool for crises to enable this kind of cooperation and to have an automatic mechanism ready to roll out. Because in a crisis situation, a war, a pandemic, time is really critical to react. If you have to do all this complicated stuff, you lose several weeks. If we had a process which could be similar to the process we used, that would make it easier for everybody. Also, because the EU, it's unclear what kind of authority it has to do this. So it's not clear in the treaties that it has this like Defense Production Act type authority. And I think it would make sense for it to have it for, real crisis situations like we experienced during the first wave of COVID.
Yeah, and when you're talking about saving weeks, I mean, how many thousands of lives is that? I mean, it's just looking at this particular crisis, this particular pandemic, it's meaningful. It's very meaningful.
Exactly, and I think the competition authorities were really understood the situation. They were working very closely with the health authority because they're in the same commission, of course. So they understood the necessity for this. I think that was no problem. But still, it's a legal process, and both sides need to be comfortable with what ultimately is established, and that takes some time. We spent all of our weekends and things like that at that time just doing this kind of thing. And like you said, in Europe, we had, I think, well over 700,000 deaths directly related to COVID, so we were probably one of the most impacted regions in the world, if not the most. So, being very timely here was truly life-saving.
Important stuff, Adrian. Thank you, and so much to cover. But thank you for sharing and getting us started, at least thinking about these issues. I'd like to shift gears just a little bit, maybe something a little bit lighter. Ask you, what advice do you have for younger lawyers that might want to get into doing what you do?
Well, I think pharmaceuticals is probably the most regulated product industry in the world, because you have scientific regulation, you have competition law, you have market regulation. So, it's really, really complex. And, understanding the links between, say, patient access and legal issues, intellectual property rights. I mean, it's a fascinating area. It's complicated, but it's also very rewarding. Like when you work on a project like that for COVID, you really feel like you're engaged directly in trying to keep people alive. And that's super motivating. And I think the pharmaceutical industry offers a lot for young lawyers, who can cut across different legal regimes and how they intersect and interplay. It's a very fascinating space, I think, for young lawyers.
It's interesting because I think one of the advice, as we talk to our guests about this, one of the pieces of it which we hear sometimes is learn a sector, right? If you're a young lawyer and you want to learn a sector, because you'll face different challenges across that sector. And I think pharmaceuticals is a really interesting sector for the reason, heavily regulated, very interesting for all the reasons. And by the way, pretty important. People care a lot about pharmaceuticals as well. So a lot of attention there as well. Tell us something interesting about yourself, maybe just even a little bit more light. Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
Okay, well, maybe something that's a little known. So I do engage in a lot of sports and things like this, because I think I'm in a high stress job. So even though I'm getting on in age, I still go and pull out my back regularly playing sports like water polo and karate. And so that's, I think, some other advice I would give to young lawyers is find yourself a passion, sports or a hobby or something like that allows you to disconnect from work. Because when you operate in a kind of high stress, complex environment, you also need to disconnect. And something like that, even for an older guy like myself, even though sometimes I come back to work with a lot of back pain and things because I'm too old to be doing this, I still feel better in the end because I've disconnected from work that way.
Good advice. Okay, let's go to our final segment that we call the Curious Hat.
And now it's time for the Curious Hat.
When we are all together, we have an actual hat, and in the actual hat are actual questions, and I will hand you the hat, and you would pull a question out of the hat, and we would read you that question. That would be the question you answer. Fortunately, since we're not together these days, I have a list of questions in my right hand. They're numbered from 1 to 25. So choose a number between 1 and 25, and I will read the question that corresponds with that number.
Number 8.
Number 8. What is your perfect weekend?
Okay, so my perfect weekend is when the weather is nice, because I live in Brussels, Belgium, where it rains a lot, and where the weather is usually terrible. So starting with good weather. Second, it's where I can actually go out and do sports, because I do a lot of those sports that I mentioned with my kids. So I do them with some guys like my age, but I also coach my kids in those same sports. So I enjoy that. So I think that's a perfect weekend. And then finally, the, let's say, most important part is that I can have an aperitif. That means a drink with some small snacks just before dinner with my wife, who usually organizes this in a very nice style.
Okay, so tell me about the aperitif. What is your favorite? How does that all? What is your favorite example of that?
Okay, so there are two options here. So either we have a nice glass of wine associated with a small snack, like some salami and cold cuts and various things like this, or other things like hummus or some kind of things like this. Or we have a mixed cocktail, like with fruity drinks and things like that. And we usually take it in the back garden here when the weather is nice, as I mentioned. And that's very important. I mean, I think in Europe, an evening without an aperitif is, not an evening. So I think it's something that happens more sort of daily, not just on the weekends.
All right. Well, this is great. Adrian, thank you. And we will see you all next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.